President Donald Trump tonight doubling down on his false claims that President Biden authorized the use of deadly force against him during the FBI raid of Mar-a-Lago last year. Special counsel Jack Smith seeking a gag order to stop Trump from making the statements, saying they pose a risk to law enforcement. Here's ABC's Mary Alice Parks.
Tonight, just hours after special counsel Jack Smith.
Folks, sit down for this one because what I'm about to walk you through is one of the most unprecedented attacks on the United States Supreme Court by a sitting president in modern American history. Donald Trump lost a massive case at the Supreme Court on February 20th, 2026 in the matter of learning resources versus Trump, decided 6-3 against him. The Chief Justice John Roberts wrote the majority opinion, joined by Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson. And here is the part that has been making Trump absolutely melt down in public view for everyone to see. Justice Neil Gorsuch joined that majority and Justice Amy Coney Barrett joined that majority as well. Both were Trump appointees, both handpicked by him personally during his first term, both chosen with the explicit expectation that they would serve for the rest of their lives on the highest court in the land and advance the kinds of priorities he wanted. Yet both voted against him in this landmark ruling that struck at the heart of his economic agenda, and ever since that moment, Trump has been on a full-scale rampage, attacking justices by name in press conferences and on social media, calling them a disgrace, calling them an embarrassment to their families, and saying that Republican appointees are, in his own quoted words, weak, stupid, and bad. This is wild. Can you truly believe that this level of direct confrontation is happening at the highest levels of American government right now? Before we go any further, let's be honest about the media landscape we are all navigating today. You can't really trust mainstream media anymore to give you the full picture without layers of spin and selective framing that serve their own interests. That's precisely why outlets like Pump Politics exist, to bring you real stories, real context, and no corporate spin that twists facts to fit a narrative. If you want to stay ahead of the headlines and get the unfiltered developments delivered directly, join our free newsletter. We'll send the news straight to your inbox every single day without fail. Just click the link in the description to join right now. And if you want to go further and support the work we are doing here to cut through the noise, join our community. Be part of the group that actually cares about digging deep into the truth no matter where it leads. Alright, let's dive back into the core of this story because there is so much ground to cover and every detail matters in understanding how we got to this extraordinary point in our constitutional history. Today, even as we speak, the judge overseeing aspects of Donald Trump's classified documents case is hearing arguments on whether to impose further restrictions barring him from making public comments about FBI agents involved in the investigations.
Prosecutors have argued forcefully that the former president's repeated public statements could put those agents' lives in real danger. This comes directly in light of his ongoing false claims that the agents who executed the search warrant at his Mar-a-Lago home were somehow out to kill him and his family, framing routine law enforcement actions in the most inflammatory terms possible. Reports from CBS News and other outlets have highlighted campaign reporter Katrina Kaufman providing updates from outside the courthouse in Fort Pierce, Florida, painting a picture of tension and high stakes in the legal proceedings. The questions prosecutors must prove to secure such a limited gag order revolve around demonstrating a clear and present risk to safety, not just disagreement with the content of speech, but actual endangerment that crosses into unprotected territory under legal precedents.
What Trump said about that search warrant execution involved painting the FBI as enemies of the state, suggesting malicious intent at the highest levels, which has fueled division and concern among those monitoring threats to public servants. Let me walk you through the specific February press conference that marked a turning point, because it was exactly the moment when the President of the United States decided to publicly attack the Supreme Court justices he himself had personally appointed. Right after the tariff ruling came down on February 20th, Trump stood at the lectern in the White House briefing room, surrounded by reporters and cameras broadcasting live to the nation and the world. He declared that the Supreme Court's ruling on tariffs was deeply disappointing, and he expressed that he was ashamed of certain members of the court, absolutely ashamed for what he saw as not having the courage to do what he believed was right for the country. He then escalated by calling the justices a disgrace to our nation. Going even further, he added that he thought it was an embarrassment to their families, repeating the point for emphasis, calling out the two of them specifically as an embarrassment to their families. Those are the direct words of the American president about Supreme Court justices he had appointed with great fanfare. Think long and hard about what it actually means for a sitting president to call his own Supreme Court appointees an embarrassment to their families in such a public forum. This goes far beyond normal political disagreement or policy critique. It enters territory of personal humiliation and institutional undermining that has few, if any, parallels in recent decades. This is not the traditional way presidents have handled disagreements with the court. Previous presidents from both parties have voiced strong objections to rulings that went against their agendas. Barack Obama famously criticized the Citizens United decision, arguing it opened the floodgates to unlimited money in politics. Joe Biden spoke out against the Dobbs ruling that overturned Roe v. Wade, calling it a setback for women's rights. George W. Bush expressed disappointment over certain rulings like Hamdan that limited executive authority in wartime. Every president has had moments where the court frustrated their goals, but none in modern times went so far as to personally attack Supreme Court justices by name, publicly humiliating them and dragging their families into the discourse on national television. Trump did exactly that on camera in the briefing room with the world watching, and he has shown no signs of stopping since that day. The intensity and personal nature of these attacks have left observers across the political spectrum stunned by the departure from established norms of presidential restraint when it comes to the judiciary. Are you kidding me with this level of direct assault on the independence of the judiciary? Consider what Trump said just this past Wednesday, as reported by the Center Square and other sources. He lashed out at Supreme Court justices, calling some Republican-appointed members weak, stupid, and bad. Those are his exact words from a social media rant, directed at justices he appointed, the very people now hearing cases that touch on the scope of his executive power. He followed up with posts claiming that the Republican justices don't stick together, and that the radical left Democrats don't need to pack the court because it is already packed against him in his view. This is the leader who reshaped the court into a 6-3 conservative supermajority during his first term, now turning around and accusing that same court of being stacked against his interests simply because two of his own picks applied the law in ways that did not align perfectly with his immediate preferences. This kind of real-time attack from the president on his hand-picked justices raises profound questions about expectations of loyalty versus the constitutional duty of judicial independence. Now, let me expand on the specific birthright citizenship threat that hangs over the horizon, because this is where the situation moves from unusual political friction to something genuinely dangerous for constitutional stability. The Supreme Court heard oral arguments on April 1st in Trump versus Barbara, the case challenging Trump's executive order that sought to deny citizenship to children born in the United States to parents who are in the country illegally or on temporary visas. The 14th Amendment has been interpreted for over a century and a half as granting citizenship to nearly all people born on U.S. soil, a bedrock principle rooted in the post-Civil War effort to secure rights for freed slaves and their descendants. During those oral arguments, several justices, including Chief Justice Roberts, expressed clear skepticism about the administration's position. Roberts specifically pressed lawyers on how the government could expand narrow historical exceptions, such as children of diplomats, to exclude an entire broad class of children of unauthorized immigrants. A ruling is expected by summer, and Trump is already preemptively attacking the court, laying the groundwork to question its legitimacy if the decision does not go his way. Think carefully about the wording of Trump's specific preemptive strike on this birthright citizenship case. He posted on social media that if they rule against our country on birthright citizenship, which he predicted they probably will, it will cost America massive amounts of money, but more importantly, it will cost America its dignity. The president is telling the American people that the Supreme Court applying the 14th Amendment as it has been understood for generations would somehow be a ruling against the country itself and a blow to national dignity. The 14th Amendment, ratified in 1868 after the Civil War, stands as one of the most fundamental constitutional provisions defining who qualifies as an American citizen. By framing a potential adverse ruling in these terms, Trump is setting up the familiar playbook: lose at the court, personally attack the justices involved, claim the institution is packed or biased against him, and then move to defy or find workarounds to the decision. This pattern, repeated across multiple issues, creates a dangerous erosion of public trust in the third branch of government. Let's really dig deep into the full picture here, because the pattern of attacks is broader and more concerning than any single ruling. Understanding the specific scope requires examining multiple documented episodes spanning press conferences, social media outbursts, interactions with his own appointees, and challenges to long-standing legal doctrines. The February tariff ruling attack represents one major category where Trump named and insulted his own appointees directly. The Wednesday rant calling them weak, stupid, and bad forms another category of name-calling that one would hesitate to use even against political rivals in a heated campaign. The preemptive birthright citizenship assault is a third layer, preparing the public to reject a ruling before it is issued. The meltdown over the $166 billion in tariff refunds constitutes a fourth category, focusing on the financial fallout from his loss rather than accepting the legal outcome. All four of these threads have unfolded and intertwined in roughly 2 months, creating a sustained campaign of criticism that stands out in its volume and venom. Let me walk you through the specific 6-3 coalition that ruled against Trump on the tariffs because the makeup of that majority is what has proven so politically devastating for him. Chief Justice John Roberts authored the opinion. He was joined by Justice Sonia Sotomayor, appointed by Obama, Justice Elena Kagan, also appointed by Obama, and Justice Ketanji Brown Jackson, appointed by Biden, representing the three more liberal voices on the court. But crucially, Roberts himself, originally appointed by George W. Bush, added his weight along with Justice Neil Gorsuch, appointed by Trump, and Justice Amy Coney Barrett, also appointed by Trump. This created a 6-justice majority that included 3 justices with Republican presidential appointments, 2 of them personally selected by Trump himself. They all agreed that the International Emergency Economic Powers Act, or IEEPA, does not authorize the president to impose broad tariffs in the manner attempted. The dissent came from Justices Clarence Thomas, Samuel Alito, and Brett Kavanaugh. This was not some narrow partisan split, but a genuine constitutional majority grounded in statutory interpretation and separation of powers principles. Consider what Justice Gorsuch wrote in his concurrence, which carries special weight given his appointment by Trump. He acknowledged that for those who believe it is important for the nation to impose more tariffs, the decision would be disappointing. But he emphasized that the deliberative nature of the legislative process is the whole point of the constitutional design. The nation can tap into the combined wisdom of the people's elected representatives in Congress. In plain terms, if tariffs are the goal, Congress must pass legislation authorizing them, rather than relying on stretched interpretations of emergency powers. A Trump appointee felt compelled to articulate this basic civics lesson because the administration had claimed near unlimited authority under a statute that does not even mention tariffs once. Gorsuch essentially delivered a respectful but firm reminder that this is not how the system of checks and balances operates in a republic. Trump responded by attacking Gorsuch by name, further highlighting the tension between expected loyalty and judicial duty. The specific Roberts opinion merits close attention for its implications on future emergency powers disputes. Chief Justice Roberts wrote that when the president asserts extraordinary power to unilaterally impose tariffs given the breadth, history, and constitutional context of that authority, he must identify clear congressional authorization. This reflects the major questions doctrine, a tool used across administrations of both parties to ensure that agencies and executives do not expand into vast new territories without explicit legislative approval. Tariffs affecting an 11.7% effective rate across a $30 trillion economy clearly qualify as highly consequential actions requiring such clarity. Roberts applied established doctrine neutrally, yet Trump's reaction framed the entire 6-justice majority as a disgrace because the outcome did not favor him. The doctrine is designed to be neutral and protective of legislative primacy, but the response treated it as a personal affront. The $166 billion tariff refund situation, now fueling the latest wave of frustration, adds another dimension. The administration began processing refunds for the tariff revenue collected under the challenged authority. Trump then took to social media to rant that handing over $159 billion in refunds to people who have been ripping off our country is unexplainable. He complained that one little sentence in the opinion could have stopped this record-setting payment. In essence, he wanted the court to explicitly allow retention of funds collected under authority the court had just deemed unlawful. Courts do not typically issue such directives because remedies in American law generally require returning money collected through invalid means, much like refunds for illegal taxes. The principle is straightforward. Governments cannot keep the fruits of unconstitutional actions indefinitely. Trump views this as a travesty because it hampers funding for his priorities, revealing a perspective where rule of law yields to policy expediency. When the court did not accommodate that view, the personal attacks escalated. The pattern of targeting his own appointees is particularly noteworthy because it breaks from long-standing traditions. Trump has long referred to "my justices," expecting personal loyalty above institutional role. He invested enormous political capital in reshaping the judiciary, appointing hundreds of federal judges and 3 Supreme Court justices. Yet Gorsuch has ruled against him in significant matters before, and Barrett joined the majority here. Both were chosen for their textualist and originalist philosophies, which prioritized the Constitution and statutes as written over outcomes desired by any one president. When they did precisely that, the response was fury directed at judicial independence itself. Independence requires the willingness to rule against the appointing president when the law demands it, a feature the framers built in with lifetime tenure to shield judges from political pressure. This escalation did not emerge in isolation.
Trump's history of personal attacks on federal judges during his civil and criminal cases from 2020 onward set the stage. Judges like Tanya Chutkan, Eileen Cannon, Arthur Engoron, Juan Merchan, and Lewis Kaplan faced direct public criticism by name. In the New York case, Judge Merchan issued a gag order because the attacks risked endangering court staff and witnesses. Similar restrictions appeared in other proceedings where courts documented security risks created by the rhetoric. Scaling that same approach to the Supreme Court level marks a significant intensification. Supreme Court justices already navigate heightened threats, from protests outside homes after Dobbs, to the 2022 assassination attempt on Justice Kavanaugh, and credible risks faced by Barrett. Presidential words carry unique weight, reaching millions instantly and potentially inspiring action from supporters who have shown willingness to respond aggressively to perceived enemies.
The institution must take such dynamics seriously for its own protection and the preservation of impartial justice. To be completely fair, defenders of Trump's style offer several counter-arguments that deserve consideration. Presidents have criticized court decisions throughout history. Robust criticism falls under First Amendment protections. Trump's appointees had public records before confirmation, so adverse rulings are not surprises or betrayals. The tariff case involved genuinely complex legal questions where reasonable minds could differ. These points hold some validity. Presidents do push back on rulings. Speech enjoys broad safeguards. Records were transparent. Legal issues are rarely black and white. However, the scale and personal nature here differ markedly. Past presidents critiqued opinions without naming justices as disgraces to their families or labeling them weak and stupid. Presidential rhetoric creates unique security dynamics no private citizen can replicate.
Humiliating justices for following their records undermines the very independence the system requires. Calling a 6-3 majority, including Republican appointees, a packed radical left court stretches beyond fair criticism into delegitimization. The overall pattern does not align with normal presidential behavior, and history will record it as such. Let's break this down into clear, actionable takeaways you can carry forward and discuss with others. First, on February 20th, 2026, the Supreme Court ruled 6-3 that the International Emergency Economic Powers Act does not give the president unilateral tariff authority. Roberts wrote the majority, joined by Sotomayor, Kagan, Jackson, Gorsuch, and Barrett. Thomas, Alito, and Kavanaugh dissented. Trump's own appointees sided with the majority, vacating key tariffs and triggering massive refunds. Second, the response involved unprecedented personal attacks, calling justices disgraces and embarrassments to families, labeling them weak, stupid, and bad, and claiming the court was already packed against him, all while refunds began processing. Third, preemptive strikes on the birthright citizenship case used similar language about dignity and cost to the nation, setting up potential defiance. Fourth, this fits a documented history of judge attacks leading to gag orders in lower courts, now elevated to the Supreme Court with serious security implications for lifetime appointed justices.